Hi, everybody. This is Steve Maggi from SMA Law Firm. Welcome to Building the Bridge. I'm here with Josh Goldberg from Nath, Goldberg and Meyer, patent attorney in New York. Thank you so much for joining me, Josh.
Oh, thank you for having me, Steve.
So the first question that people ask is, what are the different types of intellectual property? Just to give them an idea of what we're talking about. What does that encompass under that title, intellectual property?
Sure. So intellectual property, I think of as property just like real estate, but for something that you can't really see, right? It's a way of turning the ephemeral, something that has no meaning, into something real. So usually that is in one of four categories, right? It's either patents, trademarks, copyrights, or trade secrets. And I'll give you a little description of each. So patents are what everybody thinks about most often when they think about intellectual property. That's when you invent something new, right? You created a new phone that works better than the iPhone. You created a new pen that lasts 20% longer. All of these are new inventions. And the way you would protect that is you would get a patent on them to make sure that nobody else can compete with you in the marketplace by taking your innovation from you. Of course, if you have a new phone, Apple is still free and cleared to sell their own iPhone, but they can't then come and take your invention that makes yours better, right? You want to be able to operate on a level playing field. And if their product is better, so be it. And if your product is better, then you should get the benefit of that. Okay. Second I mentioned is trademark. And this is basically any design, logo, name that will tell you the source of whatever it is you're selling. So if you think, for example, of Coca-Cola, that's a name, right? And I remember as a child in the 1980s, used to be you'd go into a restaurant and you go in and the waitress would ask you, what would you like to drink today? You could say a Coke. And she would come back and give you some sort of cola beverage, whatever that was. And at some point during the 1980s, that shifted to now where you ask, go and you're asked, what do you like to drink? I'll have a Coke. Well, we don't have Coke. Is a Pepsi okay? That's because they're not the same product. They're both colas.
Got it.
Coca-Cola is a name distinct from Pepsi Cola, different products. Those are trademark.
It's not cola, it's Coca-Cola.
Coca-Cola, exactly, or Coke. It's a way to identify the source of what it is you're trying to buy. Okay. So the name, if you think of Coca-Cola, the stylized design Coca-Cola with the swoosh under it, or with the red and white colors, all of those are trademarks to say, yes, I am buying a Coca-Cola, not a Pepsi Cola or an RC Cola or anything like that. Those are all trademarks. Then you get into copyrights. And copyrights essentially are any work of art in a fixed medium. So you think a novel, a song, a piece of art, all of those are things that can be copyrighted. Now, sometimes if you have a very stylish logo, you can get both a trademark and a copyright on the same thing. Stylish logo, you get trademark, and then it's really a work of art, so you get a copyright too. Just like if you sell a new product, like the iPhone, right? The iPhone has patents involved, and it also has a trademark, the iPhone.
Right, the name.
So,
yeah.
there can be overlap between all these forms of intellectual property or IP to make sure you're really protected. And then the last one I mentioned is trade secret, which people don't think of as often, but is still really valuable. It's any information that gives you a competitive advantage that you can keep a secret.
Would that be like the Coca-Cola formula or the KFC recipe?
Two perfect examples.
Okay.
The Coca-Cola formula is the #1 most valuable trade secret in existence. The three examples I always use are Coca-Cola, KFC, and Chanel #5 for the perfume.
So I've made some good guesses there.
You sure did. And the reason it works for these is, for whatever reason, the aromatics in there or whatever, you can't just put these things in a gas chromatograph and reverse engineer them. The story I've heard is there's one very old, yellowed, taped up piece of paper with the original Coca-Cola formula on it that 5 people on the planet have access to. That's it.
So I have a question for you. If you're a foreign entrepreneur and you're thinking about launching a brand here, products or services, when is too early to contact you about, how to do that, and whether you need to, patent it or copyright it overseas first, or if you need to only do it exclusively in the US, etc. When is too early or too late, I guess, to contact you about those?
Sure. Too early, the answer is never, right? Even if you come to me and we have a discussion and I tell you, you know what, maybe you should wait a little bit, at least now you have that confidence to know that you're okay. Too late is a much more important question.
Right.
For trademarks, for copyrights, it's less relevant, and I'll get to those in a minute. For patents, it's extremely relevant. So for example, if you're coming here from Brazil and you have a patent you got in Brazil, or you published what you're doing, or you put it on sale in Brazil, that sets a clock for 1 year.
Hmm.
1 year from that first disclosure until you don't have US rights anymore. So as long as you do something here in the US within that 1 year, you're okay. But if you have something that's already out there and 1 year has passed, you're not going to be able to get a patent for you. The only thing I could do is if you have an improvement, say the next generation, I could patent that next generation for you.
So if you're thinking US operation, US launch, you need to watch the timing of when you're launching that product in your home country as well, or other countries.
Absolutely. And the thing about pretty much all of these forms of IP are they're territorial. They're given by individual countries. So if you get a patent in Brazil, that's great for you if that's your base of operations. You sell there, manufacture there, you're protected. You come here to the US, suddenly you're not protected anymore unless you have a US patent.
And I think that is a misnomer. People tend to assume if they protect it, it's protected universally, which is not the case.
Absolutely not. And that is something that people have to be educated on a lot. I used to have a client that had two brothers running the company. One ran the US operations, one ran the non-US operations. And when the brother who ran all non-US operations died, they came to me and they said, hey, we know we have a lot of patents around the world. We have no idea what they are or how to find them. Can you help us?
Right.
So it took us about a month to go through everything, all the different patent office records and everything to find, okay, here's everything you own outside the US. Here's how it compares, one, to what you own inside the US, and two, to the products you're selling outside the US. And here are the holes and gaps we see. Let's figure out what to do next.
Wow. So it really takes an attorney or a group of attorneys that understands globally how this all is connected, right? So if someone has questions for you, Josh, about IP,
Yep.
or they have ideas of coming to the US or launching products or services or extending their brand, how do they get in touch with you?
Well, Steve, as you can see to my right here, or I guess you, the viewer to the left, have my name and email address, as well as my office phone number there. Easiest way to get in touch with me is almost always email. I'm on the phone on Zoom a lot, so catch me as you can, but email I'll always answer.
Wonderful. Thanks so much for sharing your knowledge and being with us today, Josh.
Thank you very much, Steve.